Hi, I'm Andrew Garcia, an estate and elder law planning attorney with SouthCoast Estate Planning, a division of Phillips Garcia Law. Now, today I'd like to talk about the basic differences between revocable and irrevocable trusts. Now, in an estate planning practice like mine, we use different types of trusts for different types of purposes. Sometimes we use trusts to avoid the probate court or to manage assets for minor children. Sometimes we use trusts to help us minimize inheritance taxes or to protect valuable government benefits for a child with special needs. And sometimes we use trusts to protect a couple's life savings from long-term nursing home care. But before using any trust in your estate plan, it's important to understand the differences between revocable and irrevocable trusts. Now, if you've watched my videos about what a trust is, you'll recall that it's a legal agreement where the trust creator, called the grantor of the trust, chooses someone to be a trustee to hold all of the property they put into the trust for the benefit of the beneficiaries. Now, sometimes when we do an estate plan for people, the clients can actually hold all of these roles. So they can be the grantors, the trustees, and the beneficiaries all at the same time while they're alive and healthy. They can then choose to name a successor trustee to take over the trust management when they're gone, and they can choose additional beneficiaries to reap the financial benefits of the trust, such as children or grandchildren, for example. But for more information about what a living trust is, go check out some of our other videos where I get into more detail. For now, though, let's turn our attention to the differences between revocable and irrevocable trusts, and then we'll talk about some scenarios where we might use each type. First, let's talk about revocable trusts. Now, revocable trusts are trusts that you create while you're living, and you as the maker of the trust, remember that term, the grantor, retain the right to either amend the trust at any time, so that means you can change the rules of the trust, or you can revoke it at any time, meaning you can cancel the entire trust if you want. It's that simple. When you make a revocable trust, you keep a heck of a lot of power because you have a right to make as many changes as you want or to cancel it throughout your whole life. Now, in contrast, when you make an irrevocable trust, you give up the right, mostly, to amend or change the trust, and you can't just revoke it anytime you want. So you generally give up a lot of power over an irrevocable trust when you make one. So why do I say mostly give up the right to change an irrevocable trust? Well, without getting too technical here, sometimes, in very limited circumstances, you might be able to retain certain rights to make minor changes to your trust. For example, in certain circumstances, you might be able to change a trustee or even change what state law will control the interpretation of the trust. But for the most part, always remember that an irrevocable trust really can't be canceled or amended. So now that we know the difference between revocable and irrevocable trusts, let's take a look at some short examples how we use them in everyday estate planning. Now, it's very common for us to use revocable trusts when we're estate planning for married couples, especially if they have minor kids or adult children who are just too young to safely manage decent-sized sums of money. It's also useful for couples who are in second marriages, and you might want to ensure that some inheritance gets to your children from a prior marriage rather than them being disinherited entirely. Now, in these instances, it might be very suitable to create an estate plan around a revocable living trust for some of the reasons we talked about. For example, both members in the couple can serve as co-trustees, so they'll have total control over all their property in the trust while they're both living and healthy. If they need investment income from their trust, they can just take it and use it. If they want to sell their house that's in the trust, they can just do so without asking permission of anyone. And again, they can amend it or even revoke it at any time. So if the situation changes in any way, they can do whatever's necessary to adjust their trust to fit their needs. It's really that flexible. Now, turning to irrevocable trusts. When we're estate planning, there are times when we'll want to use an irrevocable trust. For example, Massachusetts has a very low estate tax threshold of only $1 million per person. So if you die with assets worth more than $1 million, and this includes the value of your real estate, bank accounts, IRAs, 401ks, annuities, and even life insurance benefits, there's a good likelihood that some of your estate will be eaten up by inheritance taxes due to the Commonwealth. In that case, we might use a life insurance policy that we place into an irrevocable trust, and the death benefit will be used to pay any inheritance taxes. Now, this is a somewhat of an advanced estate planning technique, and there are a lot of specific rules about which to be aware. Suffice it to say, though, we'll be creating an irrevocable trust that can't be amended or canceled as part of this tax-saving strategy. We also use irrevocable trusts a lot when we're doing Medicaid or nursing home planning, where an older couple wants to begin giving assets away so that they can protect them from the increasing cost of long-term care in a nursing home. In this situation, I'll often create an irrevocable trust to receive the assets the elder couple is giving away. Again, Medicaid planning is a complicated area, and there are some very specific rules when you set up that type of trust for the planning to work. So be sure to work with an attorney who's familiar with Massachusetts rules regarding Medicaid and eligibility. Now, if you'd like to learn more about how revocable or irrevocable trusts can be used in your estate plan, go ahead and schedule your free family legal planning consultation with us and begin to get your estate planning and financial affairs in order.